That's okay.
What happened to Ms. Nicholson?
She had a meeting that she couldn't miss, so she asked me to come down and...
Oh, well, I'm sorry. I didn't even look up.
That's no problem, Judge.
Yeah, you're not Ms. Nicholson. Yeah.
See here, I gave it to you in your chambers. Did you put
Oh.
Okay.
Sorry about that. I did have it. All right, we are here on the issue of competency. The court has received a report from Dr. Rose from Summit. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
Do we have a stipulation to the report?
And just like that, the entire direction of this case changes. Before anyone can plead guilty, the court first has to decide one critical thing. Is a defendant mentally competent to understand what's happening? That competency report is huge. Without it, this plea hearing never even gets off the ground.
Yes, Your Honor.
All right,
Yes,
at
Your
this time, then the court's going to find that the defendant is competent to stand trial, and that will be, report will be admitted as the court's exhibit. Mr. Goodyear, what are we doing beyond that?
Your Honor, it's my understanding the defendant will enter a plea of guilty as charged to count 1 in the indictment, trespass into habitation. In exchange for that plea, the state will dismiss count 2.
Ms. Kirby, is that accurate?
That's my understanding, Your Honor. Ms. Fields has reviewed the plea form, and I believe she understands what she is pleading guilty to.
Okay, Ms. Fields, you're telling me you're going to change your plea to count 1 of the indictment. Before we get to change the plea, I am required to go over some things with you, okay?
Okay,
How old are you?
35.
How far did you go in school?
I dropped out in 12th grade.
Are you able to read and write?
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case? Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Ms. Kirby?
Yes, ma'am. Sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This document is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Ms. Kirby?
Yes, sir.
Do you feel comfortable that you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of trespass in a habitation. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison when you are released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PO.
Notice how detailed the judge is being here. This isn't just courtroom formality. This is the court building a bulletproof record. Every right is explained one by one so the defendant can't later claim, I didn't understand what I was giving up. Jury trial, silence, witnesses, cross-examination. Once she pleads guilty, all of that disappears instantly.
PRC, whichever's longer, that time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've gone over?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Mr. Goodyear, could you read a statement of facts?
Yes, Your Honor. Your Honor, by the 6th day of December 2025, Warren County, State of Ohio, the defendant Ashley Fields did by force, stealth, or deception trespass in a permanent or temporary habitation of any person when any person other than an accomplice of the offender was present or likely to be present, excuse me, in violation of section 2911-12B of Ohio Revised Code.
Ms. Kirby, anything on those facts?
Nothing on the facts, Your Honor.
Ms. Fields, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge that what he said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Ms. Fields. Quite frankly, I don't know enough about you or your history to sentence you today. So I'm going to order that, and we'll come back in a few weeks and do sentencing at that time. Mr. Goodyear, is there anything else?
Judge, nothing else other than we'd ask that she be held in the meantime.
Ms. Kirby, you wish to be heard?
Yes, Your Honor, thank you. Ms. Fields has been doing some research and has been talking to some people at Summit about some potential mental health facilities that she could be transferred to or engaged in the meantime. One of which is Nova Behavioral Health, and I believe that they have an inpatient component to their facility. We would just ask that Ms. Fields be able to participate in any assessments and see if there is a bed available that she would be able to be transferred to at Nova or any other facility. Ms. Fields is doing extremely well with her mental health, and I think that we can all see that from the last time that we were here in court. She does have an underlying substance abuse issue that she wishes to get professional treatment for. She tells me that she's never had the opportunity to get real inpatient treatment for substance abuse and mental health alike, and would like the opportunity to do that instead of sitting in the county jail. She understands that there would likely be an ankle monitor component to this and is willing to comply with any orders of the court.
Oof. That response from the judge says a lot without raising his voice. Defense counsel tried to pivot toward treatment instead of jail, highlighting mental health and substance abuse struggles. But then came the line that changes the atmosphere. Your criminal history is significant. Translation? The judge sees more risk here than the calm courtroom demeanor might suggest. And for Ashley Fields, that means sentencing will happen from behind bars, not from a treatment facility.
I am going to decline that request at this time. I quite, as I said before, quite frankly, Ms. Fields, I don't know enough about you. I'm just kind of reviewing your prior criminal history, which is significant for someone who presents the way that you do. So I'm going to deny that request. I'm going to hold you in the Warren County Jail pending sentencing. All right, that's all.
Thank you, Your Honor.